we may as well get started with this, as it turns out, timely debate. Let's hope that the Chairman Janikowski is watching the webcast, so that to help him decide which way to go on this issue. Since he's so undecided, we figured by bringing these opposing views together on this issue of whether the FCC should, will be a toothless regulator or a cop on the beat, which is slanting it a bit to the extremes, perhaps. But we'll let the panelists fill in the nuances, since when we do our marketing, we're not too good at that. But in any event, thanks all for coming here in person. This is also being webcast and will be on our website for any of your colleagues that would like to view it later. My name is Michael Calabrese. I'm Vice President here at the New America Foundation and direct our Wireless Future work, the Wireless Future program. And, we've been involved in these issues, of course, from a variety of angles, including in the net neutrality debate, which is where this seems to really, get people's blood boiling the hottest. But this question of the FCC's authority, of course, has much larger implications, and it was really kind of dramatic timing that immediately after this ambitious national broadband plan was put out by the Commission, the D.C. Circuit Court of Appeals put out an opinion in the Comcast case holding that the Commission could not under its ancillary authority, its Title I ancillary authority, it could not regulate the network management practices of Comcast and presumably of any other internet service provider. So this really opened the question or raised incredible doubts about how much of the broadband plan would the FCC have authority to move ahead on, and that included issues such as universal service reform, privacy regulation, other consumer protection regs, and of course the open internet principles, which has already been through the comment and reply comment rounds as far as whether to make the 4 open internet principles as well as 2 additional principles enforceable rules. So we have this big roadblock in the way, and all of the sort of news reports are that the chairman is still undecided about which way to go, and he has commissioners firmly on opposite ends of this. So with us, today we have a range of views, roughly 2 on either end. Since on one side, consumer groups and many internet companies argue that the FCC should reclassify at least the transmission component of internet access as a common carrier telecom service. That is, to regulate it lightly but as needed to promote non-discrimination in internet access in particular. And then there's the internet service providers and some others who advocate the position that the FCC never has, cannot, and should not regulate under traditional common carrier principles, and should just basically do what it can in a more limited fashion under its ancillary authority. So the way we'll run this is we'll have, starting with Barbara on that end, straight across, we'll have our panelists come up here for just an opening few minutes to sort of give you, kind of put on the table their perspective, and that will give us some context and hopefully raise, what are the points of agreement and disagreement. And then I'll try to guide a little bit of discussion and debate, and then we'll open it up, to your questions toward the end. So with that, let me start with Barbara Esben, who is at the Progress and Progress and Freedom Foundation as a senior fellow and director of the Center for Communications and Competition Policy. Barbara was also, before that, over 14 years at the FCC. Barbara?
Well, first I want to thank Michael and New America for inviting me to speak today. I hope I don't sound like an ungrateful guest, but I have to take issue with the premise that the Comcast decision throws a huge legal roadblock in the path of the FCC's National Broadband Plan. For one thing, the plan does not recommend that the FCC adopt network neutrality or open internet rules. The FCC has announced an ambitious schedule of actions to implement those portions of the plan that are within its control and has already begun work on these items. The FCC's implementation of the plan appears to be moving full steam ahead rather than resting dead in the tracks. As to universal service, I would say that reasonable arguments have been advanced that the FCC may redirect the funding obligations and dispersals either by resolving certain ambiguities in the text of the statute or by reliance on its ancillary authority. I'm sure that Hank will elaborate on that point. The Comcast decision only rejected arguments concerning the FCC's implied or ancillary jurisdiction to regulate Internet services based on the legal theories advanced by the agency in the appeal. The court left intact all of the FCC's expressly delegated regulatory powers over common carriers, broadcasters, and cable operators. The FCC may still take actions pursuant to its ancillary authority if it can establish a proper legal basis, factual record, and ties each exercise of that authority closely to some express regulatory power. Reclassification of broadband Internet access as a Title II common carrier service would be legally suspect and unlikely to survive on appeal. I have to say I empathize with Chairman Janikowski. This is not an easy issue, and it can't be easy being pulled in extreme directions by both sides. But the fact remains the FCC has never regulated Internet access service as a common carrier offering under Title II. In 4 separate orders over 5 years, the FCC classified all forms of broadband Internet access service as an information service because that classification best fit the characteristics of the service as offered to end users. The first of these decisions, finding that cable modem service was an information service, was upheld by the Supreme Court in the Brand X decision based on, quote, the factual particulars of how Internet technology works and how it is provided. Undoing this series of decisions will require the FCC to convince the courts that it is reasonable to imply unchanged law to unchanged facts and reach a completely different conclusion. To change its classification, the FCC will have to show that the broadband Internet service offered today is provided in a factually different way than it was 3 years ago when the FCC last examined the question. There's no empirical basis for the FCC to now say that broadband Internet access service, which continues to provide all the functionality of a statutory information service, is no longer offered as a functionally integrated service, but rather is a standalone offering of pure transmission. Reclassification would likely be seen as an attempt to evade the consequences of an unfavorable court ruling rather than a reasoned change in policy. It would be the essence of an arbitrary and capricious action. Following the Comcast ruling, the FCC would also need to show how it could be precluded from regulating Internet service providers under its ancillary jurisdiction, but can now bring them within its regulatory authority simply by relabeling the service and calling it something else. The D.C. Circuit has just rejected such an unbounded view of FCC authority, ruling that the Commission may not give itself powers over the Internet, which Congress has denied it under the Act. Finally, to succeed in reclassification, the FCC would also need to show that it has the authority to force common carrier status. Nowhere does the Act expressly give the FCC the power to compel a non-common carrier to offer its service on a common carrier basis. The courts have generally not permitted the FCC to impose carrier obligations simply because it sounds like good policy at the time. While not free from ambiguity, it may be that only Congress can provide the legal compulsion for a company to serve as a common carrier and not the FCC. To the extent the Commission has successfully imposed common carrier status in the past, it's justified its actions on the basis of the monopoly provision of an input or has demonstrated that the provider has substantial market power, such that common carrier regulation was required for the protection of competition and consumers. Starting in the late 1990s, the FCC has repeatedly found that broadband markets are competitive. Most recently, in the National Broadband Plan, it found that today's broadband ecosystem is vibrant and healthy in many ways. Even assuming the FCC could now compose a record demonstrating the exact opposite, that market forces are insufficient to protect consumers and competition, those findings would effectively preclude the agency from being able to exercise its statutory forbearance authority and regulate the service lightly under Title II. Forbearance under Section 10 is available to the FCC only where it determines that the market is sufficiently competitive to protect consumers and competition. If the rationale for reclassification is the lack of an adequate amount of competition to ensure just and reasonable behavior on the part of broadband internet service providers, the FCC will not simultaneously be able to forbear from very many, if any, provisions of Title II. We would be left instead with a full Monty of Title II common carrier regulations. My recommendation for the FCC is that it use its record compiled in the Open Internet proceeding to prepare a report for Congress identifying any market failures or lapses in consumer protection and any additional regulatory authority the Commission feels it needs in order to address those gaps. Thank you.
Thanks, Barbara. Next up is Linda Kinney, who is Vice President of Law and Regulation at Dish Network and is also a longtime FCC veteran, over a decade working there. Linda?
Hi, thanks again to Michael for inviting us and for having this very timely panel. I think there's lots of discussions going on in D.C. On this very issue. It's shocking to me how many politicians are now talking Title I and Title II as if they really know what they're talking about, but that's entertaining for all of us. And thank you all for venturing out on this hot and humid day. So I just wanted to go through a few points. I have three main points I'd like to make today. The first point is that I agree with Barbara. There's no good choice. After Comcast, the Commission really is in a bit of a pickle, backed into a corner, and there's no obvious pathway out that, one, is politically acceptable and two, legally sustainable. So I think probably all of us agree that we're all in a pretty bad situation here. My second point, which my guess is all of us also agree, is that ultimately Congress is really the right forum for resolving these issues. And if Congress could snap its fingers and have a law tomorrow, I think we would probably all be relieved that they were taking on the heat. As we know, that's not really how our system works. Many times Congress doesn't act or takes a very long time to act, and regulatory agencies are left interpreting laws and trying to adapt them to technological change. That's not at all unusual. And in this case, there's been a lot of discussion that it's sort of like a spare tire on a car. Ultimately, we want the car to be repaired, but in the interim, that car needs a spare tire. For example, we were up on the Hill doing a briefing, and it was a room full of congressional staffers. And so I said to them, because we were having this discussion about Title I, Title II, and I said to them, so how many of you think Congress could actually resolve this issue in this Congress this year? So obviously nobody raised their hand. So I said, okay, how about next year? I mean, it's a new year. How many of you think that Congress would be able to resolve this issue? Not a single person in the room raised their hand. So I said, okay, how about 5 years from now? Is that a realistic time? And maybe there was a couple of real optimists in that room, but for the most part, less than half of the people in the room raised their hand. And I was reminded once again, which I know full well, that it took almost 10 years to pass the 96 Act. So I think nobody is under the illusion, in particular Congress itself, that it could act quickly in this area. So now we're all left in a situation that, one, there's no good choice, and two, we need a spare tire approach to sort of keep the car going in the interim. So some people would say, well, don't do anything. You know, you could drive that car with no spare tire on it. And I say to that, okay, let's see how far the car goes with no spare tire at all. So then there's another group of people that say, look, even though Title I authority has been blown to smithereens by the court, let's take all the pieces, put them back together, tape it up, and see how far we can drive that car. Again, I think probably not very far is my view. So what we need to do as a community, and particularly as sort of the communications industry, is look for a way that we can actually put a spare tire on that car that works unless and until Congress gets around to actually fixing this problem long term and sort of adapting the law to the digital world that we all live in today. So with those three thoughts, I just had a couple of things I wanted to address in response to Barbara's presentation, and then I think Harold will also talk a little bit more in depth about some of the legal arguments. But two things I did want to address is Barbara said two things with respect to the Brand X decision. That, number one, the facts since that decision and since the Commission has ruled in the cable modem and other orders remain unchanged. And two, the law remains unchanged. And I think we submit that neither one of those really, in our view, is accurate. First of all, the facts have changed dramatically. Internet access service is one of the most dramatically changing, in fact, aspects in telecom today. And the Internet's constantly changing, the way people view it, the way people use it, the way it's marketed. All of those things are changing dramatically. Just one fact I'll throw out there. At the time that the Commission did its cable modem proceeding, most people tended to actually subscribe or use an email address that was provided to them by their ISP. So, for example, they would buy a package from AOL, and it would be your transmission service and your email address and maybe your web page. Quite a few things kind of bundled and integrated together as a service. But that's not how people look at their service today. And just one fact I think drives that point home. There are now 100 million Gmail users today. That's a very large number, I think, for any country. And that just shows, since Gmail you cannot purchase a transmission service through Gmail, that those people are actually getting their email address from some sort of separate provider than they are getting their naked transmission service. And from a Dish Network perspective, we are obviously a satellite video provider. And we provide standalone video service. And those customers, and in addition to that, the trend is toward folks disconnecting their landline phone service and actually migrating more toward a wireless model. So if people are getting their wireless service from a cell phone carrier and their dish service or their video service from Dish Network, then anybody who's using broadband is also getting essentially a standalone broadband service from another provider. And that's really true for any of our customers who are getting broadband services, and there are a lot of those who are integrating services together as a whole within the home. I think the second point Barbara made is that the law remains unchanged. And again, I submit that from our perspective, that is not true. First of all, the Commission clearly, having been at the Commission at that time, was under the illusion that they could use ancillary authority to protect consumers. That Title I was a legitimate way to exercise the Commission's authority and to establish jurisdiction. That decision, which we all know the FCC believed, or they wouldn't have actually issued an order, was reversed by the court in Comcast. So the law now, the Commission cannot rely for purposes of network management, cannot rely on its ancillary authority according to the Comcast case. So I would submit that there has been both a change in facts and a change in law that would justify a change on behalf of, from the Commission's perspective with respect to the cable modem order, and that the Commission could, in fact, move forward with a light regulatory touch and use sort of a 201 non-discrimination approach toward these, just the transmission component of the Internet access service, and just regulate those from a perspective of non-discrimination without a lot of heavy regulation like unbundling, tariffing, and all the other things that what I call my doomsters claim will happen. So with that, I'm going to turn over to Harold, who will, I think, talk in more detail about some of the other legal issues.
Thanks, Linda. Coming up, Harold Feld. Harold is a well-known consumer advocate and blogger who is currently the legal director at Public Knowledge, and also for many years was senior vice president at the Media Access Project, a public interest law firm here in D.C.
Thank you. Actually, I hate to disappoint Linda, but I am not planning to explore the legal issues in any great depth because I do not think that this is the place to explore the nuances of the law when this should be explored in a proper FCC proceeding. I want to thank Barbara for actually speaking with precision about what the court did and didn't do, although I do have to say there's a certain inherent contradiction in saying on the one hand that the court only decided the issue before it and said that the FCC had failed to justify exercise of its authority in a particular case, and then to later characterize a commission response to a court decision by examining things in a proper proceeding and saying that that would be an effort to evade a court decision. The fact is that we are facing a pivotal question about the FCC's underlying authority for the critical communications medium and a critical infrastructure of the United States economy for the foreseeable future. And the policy choice that is before us is whether to actually open a proceeding at the FCC and have a debate about this in which we can develop the factual record, or which we can develop the legal record, and then move forward in a reasoned manner, which we at Public Knowledge believe would lead to classification under Title II, or we can continue to blunder along. There is, frankly, something wrong when the primary debate about this is taking place in the blogosphere and on the op-ed pages, and when a filing by a former Solicitor General and a subsequent filing by the carriers and their trade associations cites to a blog post of mine as if this were the sum of all of the evidentiary and legal arguments that are to be made on the side of classification under Title II. From where we sit at Public Knowledge, where we have asked for the FCC to open a proceeding on the question of classification since the end of January, when the FCC called for reply comments in the National Broadband Plan, and where actually we have urged the FCC to consider this issue since the beginning of the National Broadband proceeding as simply a matter of better policy. We think that this needs to be done, and we need to be done right. There is too much at stake here for us to continue to play guessing games about what the FCC can and cannot do. I do want to address a couple of specific things that come up in this conversation. The first is we have made something of a fetish of history particularly the question of whether the 1998 report to Congress, known as the Stevens Report, is a definitive document about or not, whether the FCC exercised direct jurisdiction over broadband carriers, whether they were ever classified as Title II. These are interesting academic questions. I refer everybody to the letter that was filed by Susan Crawford in response to the letter that was filed by the carriers with regard to the history. But again, history is interesting and an interesting guide. But do we really believe that nothing has changed since 1998 that would require the FCC to take a look at its underlying decisions, even assuming that the Stevens Report was meant to be a definitive document for all time? And what about the FCC's other conclusion in the Stevens Report? The FCC in the Stevens Report said that there is a price that ISPs pay for being information service providers rather than being telecommunications providers. And that is that they are not eligible for universal service funds, they are not eligible for 251 interconnection or to purchase access under special access provisions. What does that do for the National Broadband Plan and what the FCC has set out? Yes, certainly the FCC is proceeding. But if we are supposed to live by the Stevens Report and die by the Stevens Report as the final and definitive word brought down by Bill Kennard from heaven on what the ISP industry will look like for now and forevermore, then we have to abide by all of the consequences of the Stevens Report, which means we will live in a universe frozen in time from a regulatory perspective. Now, some may think that is just fine. But I do want to learn from another important history, which was the history of the deregulation of the financial industry, which is a tremendously competitive industry. Back in 1999, Congress debated and ultimately repealed the Glass-Steagall law, which prevented firms from becoming too big to fail. And the argument was that this, New Deal statute was simply too old and unsuitable and imposed too many regulations upon the vigorously competitive financial markets, and what could possibly go wrong if we totally deregulated financial markets, because after all, financial services provider had incentive to provide their clients with what they wanted. What could go wrong? Now we sit in a world where we have spent hundreds of billions of dollars bailing out these firms to avert trillions of dollars in economic damage, potentially, and have suffered trillions of dollars in economic damage. We have the spectacle of the SEC perhaps being unable to enforce a complaint against Goldman Sachs where they set out and engaged in what is arguably deceptive conduct by playing both ends against the middle, and where Goldman Sachs executives under oath will not testify that they must serve the best interests of their clients in the financial industry. Are we comfortable with the level of helplessness that we have created in the financial services industry? Do we want to have the same level of helplessness in the broadband industry? Because the problem is that you can't really predict now what's likely to go wrong 10 years from now. But you can create the circumstances under which a federal agency can step in to act if something does go wrong, and can head off problems that look like they're emerging. I submit that in the context of the National Broadband Plan, in the context of our digital future, that the FCC has a responsibility to open up a proceeding to examine the question of the appropriate classification of broadband access services, and to have this debate conducted not on the op-ed pages and in the blogosphere, but before the agency where a proper record can be compiled.
All right, thanks, Harold. And then notice there's like 3, 4, or more seats in the first couple rows and around. If any of y'all standing back there would like to come up and just come and sit, or you can probably pull chairs in from just outside as well. All right. Well, finally, in terms of opening comments, we have Hank Hultquist, who is vice president for federal regulatory at AT&T here in Washington. Hank originally joined SBC, which combined with AT&T and worked at MCI for years before that. Hank?
Thank you, Michael, and I'd like to thank the New America Foundation for inviting me here today. I think the hard part about being the last person to stand up here is you started out with a set of sort of semi-prepared remarks, and then after hearing what everyone else said, you wanted to respond to all of that. I'm going to try not to give in too much to that temptation, however. I think it's important to clarify something that has been said repeatedly, both in the blogosphere and here, which is this idea that somehow the Comcast decision has destroyed or blown to smithereens the idea that the Commission has ancillary authority to pursue its open Internet objectives. I think that kind of sky-is-falling rhetoric is unfounded on the basis of the Comcast decision. In my view, the Comcast decision is a fairly straightforward application of the doctrine of ancillary jurisdiction. Importantly, it did not hold that the FCC has no ancillary authority to secure its open Internet policies or its national broadband plan objectives. If you don't believe me, you should read various comments filed in the Commission's, in the reply comments in the open Internet proceeding, as well as a recent letter filed by Vonage, which is not normally a company that aligns with AT&T on these kinds of issues. On the broader question of reclassification with respect to the open Internet objectives, I would say that the reclassification would not necessarily have any impact on the FCC's authority to adopt its open Internet objectives, in the sense that if the FCC simply went back to the regulatory regime that applied to phone companies prior to its decision in 2005, that requirement to provide the underlying transmission component on a common carrier basis had no effect on the operations of the ISPs that purchased that underlying transmission component. So that kind of reclassification would not give the FCC any greater authority to pursue its open Internet policies than it has today, because those ISPs would still be classified under Title I of the Communications Act. So really, in order to change the equation there, if that's the goal that people are thinking about, the FCC would actually have to classify the ISP services themselves as common carrier services. And this is the history that Harold was referring to that is somewhat convoluted, but I would say fairly clear that those ISP services have never been treated as common carrier services. Linda makes the point that, in fact, things have changed. Some of the facts have changed since 2002 and 2005 and 2006. And I'm sure some of the facts have changed, but there's no reason to believe they've changed systematically in one direction that would make the decision come out any differently at this point. Finally, I will just say, as Barbara alluded to, I think there are very strong arguments that with respect to the policies of the National Broadband Plan, including the realignment of the Universal Service Fund to promote broadband, there are very strong statutory arguments that the Commission has the authority to pursue those policies, both directly under the authority granted to it in Section 254 of the Act, and also under its ancillary jurisdiction. I think that there is judicial precedent on this point. The Fifth Circuit, in fact, upheld the FCC's determination that non-common carriers could be the beneficiaries of E-rate funds in a very similar context. With that, I will end my opening remarks to leave more time for what I hope will be a very enjoyable and enlightening discussion.
All right. Thanks, Hank. And this, yeah, it doesn't indeed leave us lots of time for discussion. We can flow this mostly, but to get it going, I just wanted to, I think, ask for other views on what Hank, one point that Hank teed up, which is, what exactly are we talking about regulating under Title II? In other words, if we reclassify something as a common carrier service, what is it exactly that we're talking about reclassifying? And because I think that relates to a dispute which is maybe historical, although it's not that far in the past, just 5 years in the past. So last week, at the end of last week, there were these the Battle of the Letters that were alluded to a letter from the largest carriers and their trade associations said in big, bold type, this is a letter to Chairman Janikowski, I believe April 29th, Internet access service has never, emphasized, been subject to Title II regulation. And then the next day, Susan Crawford, who's a law professor at Michigan who recently left the White House as an advisor to President Obama, and some other law professors, wrote in their letter that while non-facilities-based ISPs, such as you may remember a company called AOL and Earthlink and others that kind of rode on top of the common carrier copper, that while they were not regulated under Title II, that up until 2005, less than 5 years ago, the transmission component of DSL, for example, certainly was regulated as a telecommunication service. And so this got us into this debate about, well, are we going back? Are we just kind of rolling back what the Bush FCC did, or is this some new great new departure? And so connected with that, though, is what I asked initially is, what exactly are we talking about regulating under Title II? Because Hank points out that it may be more than the transmission component, and does that matter? I don't know if
You want to run down the table?
yeah, that'd be fine. So Harold, do you want to start, and we can get the others and come back to Hank at the end since he spoke to this most recently.
Sure. I hate to put you last again, but the fact is that I do agree with Hank with some minor caveats. That is to say that the Commission always left open the option for providers to offer broadband access as a Title II service on a voluntary basis. They reaffirmed that in the Wireline 2005 order, and some carriers take them up on it because there are advantages to Title II, or at least these carriers conceive advantages to Title II. So we know that some guys do it, on a voluntary basis. I could also quibble and point out that, in the City of Portland case, they decided it was a telecom service, so there were at least 5 years there between 2000 and 2005 when this was a telecom service. But the fact is, nobody ever regulated cable modem as a telecom service, even during the pendency of even when the Portland case was out there and after the Ninth Circuit reaffirmed that and rejected the FCC's cable modem order until the Supreme Court reversed the Ninth Circuit. So I don't want to argue that cable modem, certainly, and retail DSL for most of the country was directly regulated under Title II. That said, we got to look at the market that it exists now. We had the expected facilities-based competition did not emerge. For most of the country, we're still talking two primary wireline competitors, possibly wireless, depending on if you think that's actually competitive. But again, it's not as if we have 6,000 dial-up ISPs the way we used to. What do we do in that world? The actual question of what would we regulate is an interesting question, and again, why we need a proceeding. The cable modem order, and everybody generally agrees that in a facilities-based broadband access service, you have two things. You have the underlying telecommunications component and the information processing component. Prior to 2005, at least on the telephone side, that telecommunications component was forcibly separated out. That's the 2005. We could go back to a universe of what was the universe like before 2005. How much impact would that have, and what would that do, is an excellent question. Would competition and the threat of competition prevent providers from messing around in the same way that AOL, as the dominant dial-up ISP, was never able to exercise market power because when they tried, they just bled customers because switching was easy? Or have we missed the bus on that, and it's just too hard to switch, and we wouldn't expect to see competition emerge on that platform to discipline the market? Those are questions that need to be explored. Could you regulate the actual broadband access component, that combined service, which is what the FCC proposed to do under its ancillary authority in the network neutrality proceeding? That, I think, is what most people are looking at. If you look at the definition that the FCC put out there for what it would call broadband access service, that's in Appendix A, you'll see it's anybody that offers broadband transport from one point to another, which is classic telecom service, except through the magic of IP, it's somehow been transformed into an information service because IP is magic pixie dust that makes the transport information service instead of telecom. There's no reason you can't say, well, okay, this component is, we decide now based on the market, is not integrated with the other services that the broadband access provider offers, and we regulate that component in the same way that, on a cell phone, you regulate the voice component, and you don't necessarily regulate under Title II the things that are also offered on the platform. And the final point I'll make is to address something Barbara said earlier about forcing common carriage. We have a fairly long-standing case from the D.C. Circuit from the 1970s called NARUC versus FCC, or the NARUC 1 case for you telecom wonks out there. And that case sets forward what you look at when you're trying to decide whether someone's a common carrier or not. Are they holding themselves out to the public or a class of the public, offering services in an indifferent manner, yada, 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 a whole bunch of things there. You can run through that checklist, having decided that the broadband access component is telecom, and therefore the first step. You then decide whether it is being offered on a common carrier basis by looking at what providers are actually offering in the market. This is a fact-based exercise. It is not a hard exercise, but it is a fact-based exercise. And from our perspective, the sooner the FCC gets off the stick and starts looking at it, the better off we'll all be.
I'd like to respond to a couple of the myriad points in there, but I'll start with the last one. Yes, there's the NARUC 1 case, which is really focused on how you're holding yourself out to the public to serve. And then there's NARUC 2 that fills in that communications common carriers provide transmission of information of the user's choosing without change in the form or content of that information. And that is the part that makes it difficult for the FCC to classify the entirety of broadband internet access service as a telecommunications service. But the other point I wish to raise is these cases were pre-1996 Act. And the 1996 Act added its own set of definitions to the Act, the ones that we've been chewing over this morning and in lieu of lunch. And unfortunately, under those definitions, all information services have within them a telecommunications component. If the FCC takes that out, literally, and says, well, I'm going to regulate that separately, make you provide it as a common carrier service, there's absolutely no way to distinguish one ISP from another. In other words, one provider of an information service from any other. They'll all be common carriers because that's the way these definitions work. If we were writing the Act today for today's market circumstances, I guarantee you it would not look like the Communications Act of 1934 as amended. And that's because you get into these ridiculous arguments about statutory classification. I'm sorry I laugh because ever since the 96 Act was promulgated, this is all I have done, or well, I've done other things, but it feels like this is all I have ever done. I think that's a testament to the fact that we should not repeat this experience. When Congress does get around to amending the Act, it really has to come up with a different framework. And it should, as Harold suggests, examine factual circumstances, marketplace behavior, and come up with some kind of flexible, more light touch approach, which does not key every regulatory consequence off some definition that was written 30, 40, 70 years ago. I'll just give one example because it's a little bit off point. The definition of video programming in the Communications Act is my absolute favorite. That tells you if someone is a cable service provider. And basically the definition says it's whatever the TV broadcasters were doing in 1984. Well, that's great. What does that tell us about over-the-top video, about streaming media over the internet? It tells you absolutely nothing really of value in terms of what should the regulator's response be. It's a long way of saying I think we really need to bite the bullet and re-examine the act.
Linda?
I don't want to repeat everything that's been said already, because I think we've gone through a lot of the history, both of the Act, of the definitions, which are never quite appropriate and always unfortunate. And also, Harold has mentioned a long line of cases that have interpreted the law in this area. But what I'd like to do is go back to one of my first points, which is, yes, we all agree this needs to be revisited by Congress. Ultimately, we're trying to fit a square peg in a round hole, but like Barbara said, that's nothing new in this context, because we've been doing that for a long time, including in the context of video programming. And I think that from our perspective, what's important here is less, yes, you would have to justify it from the Commission's perspective, but we do think that the underlying transmission facility really is sort of the copper wire, and it's evolved into a fiber, and it's really very similar to what was regulated prior to the, well, actually, all the way back to the 34 Act. Is sort of a fundamental and very critical national infrastructure. And even though it's evolved from copper to fiber, and people are now using the fiber for VoIP services and other telephony type services, we think that underlying transmission component does need to be made available on a non-discriminatory basis. And we can talk about that further, but I think from a perspective of what's happening today in the marketplace and how these services have evolved, and again, the changes that have occurred since the Commission began this process, we think it's due for a fresh look at the Commission, and like Harold, we would urge the Commission to begin a proceeding so that we can do a fact-based inquiry.
Linda, let me just jump in a follow-up. Because I was asking what exactly would we be regulating? Would regulating that bringing that transmission component, under Title II, then would that also get at the sort of the internet service issues that concern Dish, for example? So so you all are concerned about the return path for your video service, because essentially your competitors, your customers for your video service, for your satellite digital video service, then have as their broadband service one of your video competitors for the return path. And you may want to explain that, but would bringing the transmission component under Title II, get to those concerns that Dish have about the potential discrimination on to internet companies or internet services like Dish's?
Yes. So from a competitive, just thinking about this from a business perspective, we obviously provide a standalone video service, and what's happening in today's market, and we think probably will increase dramatically over the next 5 to 10 years, is most customers are now looking for an integrated service, both live television, so linear TV channels, combined with an internet or an IPTV service. So people may want to access old movies, for example. The best way to do that is over the internet, because you can do it on a sort of individual basis. But when you're looking at live broadcast TV, such as an HD Super Bowl experience, the most efficient way from a technological perspective to deliver that experience really is via satellite, because it's a point-to-multipoint. It's not over the wires. So you have a situation where you have evolving technologies, you have consumers who want a bundle of services, and from our perspective, we would bundle both the satellite provision and our linear channels along with an IPTV service where people could access things over the internet. And our problem is that the providers, our competitors are vertically integrated. Unlike other countries in the world where sometimes you're not allowed to vertically integrate, here we are, and our competitors from a video provider's perspective, are able to provide the internet component too. And to the extent they can degrade or block anything provided to a Dish Network subscriber over the internet, then that's unacceptable from a competitive standpoint from our perspective. And we do think that having just 201, 202 authority over this underlying transmission component will require these providers to provide us non-discriminatory access to that pipe.
Okay. Hank?
I mean, I think that really goes back to your original question, Michael, which is exactly what is the thing that's subject to 201 or 202? And Harold alluded to the fact that there may be some phone companies who have chosen to continue to operate under Title II. And there are actually hundreds, but the thing they operate under Title II, and you can look it up on the FCC website, it's the NECA DSL tariff. Under the NECA DSL tariff, they provide a Layer 2 handoff to any ISP that wants to buy that service, and that can be either an ATM handoff, a frame handoff, an Ethernet handoff. They list a bunch of different Layer 2 technologies. The ISPs, in turn, including these companies' ISP affiliates, are the ones who put the DSL modems on top of that service. They're the ones who provide the packet, the IP layer transport, as Harold was talking about, the pixie dust, is being provided by the ISPs. So if that's the thing you put under Title II, what those hundreds of phone companies are doing today, that doesn't get you to where Linda wants to go. Because ultimately, the thing you have to put under Title II to deal with her concern, which sounds to me like sort of a traditional antitrust concern, is the thing you have to put under Title II there is the IP transport. And that's been our point, that that's the thing that's never been under Title II. And it's not just for phone companies that it's never been under Title II. Even for other facilities-based providers of IP transport services, you can think of backbone providers like Level 3 and Cogent. You can think of a lot of players in this market. Akamai, there are a lot of people who have their own transmission facilities who use IP transport as the way to carry things across those transmission facilities. And those are all things that are potentially effective if you decide that IP transport is a common carrier service.
So, Harold, do you really want to regulate pixie dust?
My problem is I don't believe in pixie dust. I do have to say that I do have to say I read the definition of information services and the definition of telecommunication services, both of which, by the way, are different from telecommunications or common carriage, differently than Barbara does. But this is why we have legal proceedings to sort out when in information service it says delivered via telecommunications, and in telecommunications it says move data from one place to another. Move data of the users choosing from one offer to move data. It's complicated. But the fact is, as you can tell, there are a lot of terms, legal terms at play, some of which are, reference each other. They are supposed to be technology neutral. So the question of who's using IP for what is, again, it seems to me the fundamental question is not, are you using IP or not, but what is it that you're actually doing using any kind of packet switch technology or any other kind of packet switch technology. If you're doing stuff like what Akamai does, which is sort of goes back to the classic definitions of what an enhanced service is, going all the way back to the Computer One proceedings, or you're moving stuff around in your private network using telecommunications but not offering telecommunications to the public, that's different from a situation where you are offering telecommunications to the public, or at least are offering your service to the public at large, and you would want to look at whether it meets the definition of telecommunications.
Would the line be drawn on, so if you're regulating just the transmission component, but you also want to reach, the network management practices, would the line be whether or not the ISP is touching the customer? In other words, whether it's a terminal access monopoly, in effect.
Wait a minute, which customer?
Well, the end,
Because
either
for-
the end, well,
For AT&T's, from
the
AT&T's,
purchaser
from
at the home or
AT&T's
business.
perspective, all of these entities are potentially customers of ours. Akamai is a customer. Large corporate, large content providers are customers of ours. Residential broadband subscribers are customers. And they all buy this thing we're calling IP transmission services from us. So potentially all of those entities are the customer. So it's not clear to me that there's a way of segregating, saying this group of customers, when they buy this service, it is common carriage, but this other group of customers, if they buy the service, it's not common carriage.
Sure there is, because we always have done this. And the fact is that even back in the days when it was all just telecom, and we looked at whether you were holding yourself out, again, this is the phrase, are you holding yourself out to the public or a class of the public in an indifferent manner, et cetera, et cetera. When AT&T sells its DSL service to residential customers, you can look at what they're advertising and who they're advertising to and what they're offering to provide and what they're offering to serve and say, okay, that looks like a particular thing. When they engage in private negotiations with Akamai or other large enterprise customers in a way that back when they were just a phone company, they would engage in large private negotiations with enterprise customers to provide certain things, you can say, okay, does that look like a telecommunication service? And if it is, does it look like a common carrier service? So all of these things are certainly fact-based. I think that's one of the reasons why my frustration of trying to define all of these things in an abstract, in 2 minutes, without regard to, 70 years of common carriage history, 15 years now of interpreting the 96 Act, and several thousand pages of what's actually going on in which segments of the market is an exercise that I think is somewhat confusing and somewhat frustrating to all of us. And I agree that your question can't easily be answered at this table, but I do think it could be answered in the context of a real FCC proceeding.
Any comment on this down there?
I think it would be a mistake if that FCC proceeding were a rulemaking as opposed to perhaps a notice of inquiry where issues like this can be debated without the prospect of immediately having regulatory consequences flow from the conclusion of the debate. I have listened to the descriptions of how the facts have changed since the earlier classification decisions were rendered, and I remain unconvinced that they have changed enough to move the regulatory classification from information service over to telecommunications service. At the time these decisions were made, it was debated, well, what if the consumer doesn't use all of the capability the cable modem service provides? And the FCC concluded it doesn't matter how much of it you use, it matters what's offered. And the offering itself was an integrated service. And the Supreme Court said, yes, that's a reasonable interpretation of the facts and the law. I personally don't think the service has morphed that far away from the way it was developed. I have been a customer since 1996 or so as to boot, and it doesn't feel different to me. I use it pretty much the way I've always used it. Of course, I haven't conducted a public interest poll and polled the public and tried to determine what do you think you're getting from this service. It might be an interesting exercise. But I think initiation of a rulemaking where the Commission would be proposing to treat these services under Title II and seeking comment on that proposal would be a mistake. And I think it would be a mistake from a policy perspective because I think it will cause forward motion on implementation of the National Broadband Plan, if not to come to a screeching halt. I wouldn't suggest that. But it would be like throwing sand in the gears. Everyone's attention will now turn to fighting these painful regulatory classification questions, trying to prove the service is different, no, the service is the same. I don't really see where it gets us, and I say that because I also don't see a huge, looming marketplace problem. Linda has identified a fear on the part of a competitor as to the actions of a vertically integrated competitor that also carries their bits across the universe to the end user. It's a legitimate fear, but we just haven't seen this behavior in the market, and I agree with Hank. It sounds like a competition problem, which the Federal Trade Commission or the Department of Justice is also free to investigate and take action on. One last point. If the FCC were to move forward and reclassify these services as common carrier offerings, that would end Federal Trade Commission jurisdiction. They simply have no jurisdiction to enforce their set of statutes against common carriers. And I think that would be a mistake and bad for consumers.
I just want to respond to that if I could. I think we have actually seen a problem here, and one of our biggest concerns is that if nothing is done and we wait for Congress, which we've already established is 10 years away, then there's no forum for anybody to go to if there is a problem, and particularly if there's a problem from the perspective of a competitor or some sort of anti-competitive practice. And so we have a few examples of this already. Obviously, lots of people cite to the Madison River case, BitTorrent. I'd like to read a quote from David Cohen that he stated on January 11th, 2010, he said, and this is a direct quote, which is actually on his website or the blog, "We felt our network management practices were reasonable and consistent with the Internet policy statement." So this is a situation where you have reset packets targeting particular content, and he is still saying in 2010 that we thought those network management practices were reasonable. Where does one go if the FCC doesn't have the authority ultimately to enforce a non-discrimination standard? There's no real forum for resolution. And the example I would like to point to with respect to Dish, we also purchased a company called Sling Media. And in April 2009, we requested that Sling Media be, actually in this case, we were actually trying to get our app approved. And the response back from AT&T was that under their terms and conditions, they were not permitting redirected video under their network management practices. Well, we thought that was unreasonable. First of all, what is redirected video? People redirect their video all the time. That's what routers are for. It's no different. It's no more of a bandwidth burden if video goes one direction or another direction. It's directed all over the place. So that to us was a very unreasonable management practice, on top of the fact that the Sling application, because it's bandwidth sensitive and it adjusts based on the bandwidth that's available, was actually taking considerably less bandwidth than our competitors' services, such as the Major League Baseball application and others, which were much more bandwidth intensive than Sling. So we had no place to go, and we ended up going to the FCC and saying, look, this is a problem. Our bandwidth, our application is actually consumes less bandwidth than this whole redirected video thing. We don't think that's a reasonable management practice. And ultimately, after sort of going through this for months and months and months and months, the FCC decided to bring the two parties together just informally. We also filed some comments in the net neutrality docket saying this was an issue. And the week of our FCC meeting with AT&T, which was scheduled for that Friday, we got a call from AT&T and said, oh, guess what, we're going to approve your application. So the night before the meeting, we actually signed a joint press release, and we didn't have the meeting on that Friday. But that's an example of why we need a backstop. If there are practices, and in both of those instances it was a network management practice that we thought was unreasonable as a competitor, we need a forum or a backstop to resolve those issues. And that's from a practical and a business perspective for us, what this debate is about.
So, Chairman,
I guess I'd like to respond to that.
all right, go on.
I guess I don't think it's the same to point to two situations, one of which the regulator had to resolve, the other of which the parties resolved. Agree that there were discussions with the regulators, but ultimately the parties resolved it, I would say, far more quickly than the kinds of issues that people normally bring to the FCC that are well within the FCC's jurisdiction. So to my way of thinking, the sling example is a good example of how parties can in fact resolve these issues without the intervention of regulators and resolve them in, compared to situations where regulators are involved, fairly timely fashion. I will say I have issues that we've been seeking to get resolution from the FCC on, ranging from things like, access to, regional sports networks and problems with traffic pumping, and that the FCC has been sitting on them for years. And so this, example of something that was resolved in well under a year, I think actually is, should teach us the opposite lesson.
Okay. And let me raise another thing that's come up, and that is, Chairman Janikowski is no doubt weighing to a considerable degree, the effect of, let's say, if you open a proceeding on this, what its impact may be on somehow distracting or delaying from implementation of this ambitious broadband plan on the one hand versus how much you can actually accomplish on many of these issues if your authority is in doubt, and if the inevitable loser or set of losers in each different proceeding take you to court and challenge your authority. So when Barbara first got up, she questioned, whether in fact the commission is, would be under the status quo now, post Comcast, whether the commission in fact would be a toothless regulator, or were we grossly overstating? So I guess the question, just kind of maybe a quick response from those of you who'd like, is what does the FCC have ancillary authority to do, or maybe more importantly, to not do now after the Comcast proceeding? So, for example, on issues such as universal service or consumer protection, like transparency. For example, New America has, had proposed a kind of a broadband nutrition label, so that it would be disclosed to consumers what your actual, rather than advertised, speeds are, things like that. Privacy, and then of course the open internet principles, which are not just what seems to some people like somewhat esoteric issues, like the reset packets on peer-to-peer, but even basic things such as the consumer choice to attach any device that doesn't harm the network, to run any application you'd like, to access any content over the web, because you wonder if some ISP somewhere might decide to behave as badly as Apple and start to decide what's appropriate for everybody to see and do on the internet. So I'm wondering, if you all have a view on, kind of, what does this really mean? What is the FCC losing authority to do potentially?
Maybe I'll go first this time so people can then respond. I think that look at what the Comcast decision actually found. The Comcast decision found that Section 230 was not a grant of substantive regulatory authority. Comcast, so therefore the FCC cannot proceed under any ancillary jurisdiction theory that invokes 230. They also found that the FCC itself had found that, and was still bound by a finding that 706 does not create an independent source of regulatory authority, did not opine on whether the impact of the FCC changing that view of Section 706 would be on further decisions. So 706 is kind of up in the air depending on what the FCC does with it. Did not address the Commission's arguments under 201, so potentially 201 is another avenue that the Commission could point to as a source of ancillary authority. And with respect to 623, it was not argued that there was an impact on the pricing in terms of services associated with the basic tier, which the court pointed to as what the Commission's authority under 623 is. Frankly, when I read Dish's reply comments in the open internet proceeding, I see them making that argument. I see Dish saying that competition in this linear channel business is dependent on there being some, standards on this internet side. So those are all arguments that were not addressed in the Comcast decision, and all are potentially open to address the things you suggest. I've already talked about universal service, so I won't dwell on that one. I view universal service as kind of the easiest one of them all.
I do agree with both Frank and Barbara that the Comcast case really is sort of a narrow opinion in the sense that what was before them was really the network management practices of Comcast. So from our perspective, that's the real issue here, whether the Commission really does have Title I ancillary authority. And it seems pretty clear based on the court's opinion, they really go out of their way to sort of tick down the list of all the various sources of prospective authority and then basically dismiss them all. So that does not, however, speak to a lot of other issues that Michael just listed. And so there's an open question about some of those, and certainly the Comcast case does sort of narrow what the Commission did view was its Title I authority. I think there's no question about that. Did it completely get rid of Title I authority for all purposes? I think the answer to that is no, and that's my personal view.
I completely agree with Linda. The case left the doctrine of ancillary authority in place, and that simply means that the types of actions the FCC has historically taken under this doctrine remain open to it if it can demonstrate the close nexus between the activity it wants to regulate and the regulatory authority to which it is ancillary that it do so. The original Computer 2 and 3 rules were adopted under ancillary authority. The FCC demonstrated to the satisfaction of the D.C. Circuit that it had to regulate the enhanced or information services provided by common carriers in order to protect its jurisdiction over common carrier rates, terms, and conditions of service, and the court thought that was perfectly fine. The problem with using ancillary authority to regulate all or part of the internet services provided by telcos and cable companies today is it would be hard to find a unifying theory of ancillary jurisdiction given the way the doctrine works. In other words, you might end up with a different set of rules for entities that are otherwise common carriers that are providing an information service than you would for a cable operator that is also providing an information service, because you could tie some rule concerning a cable operator's interference with the video programming provided by a competitor over the internet theoretically to some Title VI authority, such as Section 623, authority over basic cable rates. The problem in that specific case is that the Commission's rate authority at this point is highly attenuated. It is nowhere near as plenary as the Commission's Title II authority over common carrier rates under Section 201 and Section 202. One of the reasons the Commission went for the information service classification in the early part of this century was the belief that if these companies are competing head-to-head in the marketplace providing high-speed internet access service to consumers, they should be under a relatively uniform regulatory structure. And the FCC attempted to erect that under Title I. But for the life of me, I have never understood the arguments they have put forward. And that's why I don't totally agree with Linda's position that the law has changed radically since the cable modem decision. The cable modem declaratory ruling had a rulemaking attached to it where the Commission was positing the many ways it could nonetheless regulate the cable modem service under its ancillary jurisdiction. Needless to say, the rulemaking is still pending, but the bases for that action were not clear to me then, and they remain a bit fuzzy in my mind today.
All right, a couple of things. My short answer is I don't bet the mortgage in Las Vegas, and I don't bet the Internet and the future of the Internet on Title I, because what we have seen from the analysis that the D.C. Circuit has used, and I happen to agree with Steve Pearlstein's op-ed that the D.C. Circuit is a fairly activist court in this regard. But nevertheless, they go through and they do a whole bunch of analysis and hand waving, and they look like they leave something open here, but then they close it over there. And the FCC has been down this road with the D.C. Circuit a whole bunch of times. So what could you do under Title I? Beats crap out of me, which is the problem. The second thing is, my worry is that Title I is either too narrow or too broad. If it's broad, if Title I, we at Public Knowledge in particular, having dealt with ancillary authority for broadcast flag and having argued in the case that was most cited by the carriers for why there was no ancillary authority here, the American Library Association case, that there are limits to ancillary authority. The notion of unconstrained Title I authority is troubling. We've argued, going back to the first network neutrality comments, that all of this needs to be tied to the transmission component, that that's the core FCC jurisdiction. My concern is that if you do some magic with 706, you get an unbounded theory of Title I that really does sweep in all of the Internet and not just the broadband access component. On the other hand, I also worry that you end up with a very narrow Title I over which carriers get essentially a veto right, where we have these negotiations about what the major carriers will or won't accept. We get informal brokerage of disputes for big players like Dish and AT&T, and everybody else gets screwed. And that world worries me also. I'd like this to be on firm footing.
So let's open it to the audience in just 1 minute, but I just want to get a quick follow-up on what Harold raised, which I think is one remaining important point, which is, those, again, the letters that I mentioned last week to Chairman Janikowski to help him decide that, the carriers have argued that providers of Internet, what I would consider to be Internet applications, content, and services, such as Netflix and Google, would be swept in and regulated as Title II common carriers. Whereas, I think consumer advocates and some others, such as Harold, would say that bringing just the last mile terminating connection, the transmission component under Title II, may have exactly the opposite effect to kind of put up a fence that makes it clear that the Internet companies are not subject to that kind of regulation, whereas relying strictly on Title I ancillary authority could be a kind of potentially unconstrained regulation of the Internet companies. So kind of which is it, or how do you all see it, Barbara?
I don't think that what you've described is at all consistent with the way the statutory definitions work or the way the Act gives the FCC regulatory authority. There is no regulatory authority granted the FCC over something called the transmission component. The FCC has regulatory authority over a telecommunications service, a common carrier service. So the minute you start teasing out this transmission component from the information service to call it something else, I don't know where you draw the line on who is subject to this rule under the terms of the Act. The Act does not actually speak in terms of, are you facilities-based or do you have market power? These are the two criteria that I often hear are going to guide the Commission to determine who gets subject to the new rule. So Akamai know why. Well, they don't have market power or they're not facilities-based. But AT&T, yes. Well, why? Because you're facilities-based and we now declare that you have market power. But the terms of the Act are not written to take these criteria into account, and that's part of the problem. So I think the idea that you tease out this component and say the FCC has always had jurisdiction over this is wrong, because today it's not being offered on a common carrier basis.
I just have to say a couple of things. Lord knows you're not going to get a quick answer to this, but I'll try to be quick. Obviously, Barbara and I disagree, and I'd love for the opportunity for us to each present our 40-page filings to the Commission on the subject. The short answer is we have done this. We did it with the CALEA statute, where we decided that you could tease out the underlying telecommunications component for 47 U.S.C. Section 1006, even if, for purposes of Title II regulation, the nature of the word offer was going to be the determining factor. But with regard to CALEA, the fact that CALEA says, thou shalt not apply CALEA to an information service. Yeah. The FCC said, well, but for purposes of CALEA, you broadband access provider guys and the broadband access service you're providing are going to be treated as telecommunications. And the DC Circuit says that's cool. So there's something in there that's been regulated as a separate, that's been teased out and treated separately for different purposes. Brand X, for its own, bless this, the Comcast court in passing said, well, what Brand X appeared to be doing was saying that you could impose, potentially under your ancillary jurisdiction, separate requirements for the cable telecommunications component, although in fairness, while the Comcast court kind of dropped a little hint you might do that, they didn't actually go all the way and say you could. And it would be a peculiar outcome that you could do structural separation and not network neutrality under ancillary authority. But the fact is, there's the real point to this debate is in March, before the Comcast decision, the exact same arguments were being made about ancillary authority. And everything carriers said about ancillary authority, they said there is no such thing for you to have to regulate the open internet. They said that you would have to apply it to Google if you were going to apply it to AT&T. They said all the terrible bad things about Title II. And then when the Comcast decision came out and the alternative of having no Title I authority was that you might have to do this under Title II, suddenly ancillary authority became cool again. And that troubles me, because we should not be deciding this based on I don't like, what Title II might do, so I'm going to, agree to a little Title I compromise to get you out of our hair. Janikowski made a commitment that this FCC wasn't going to do those kinds of political deals, and I'm really hoping that he will stick to that.
This actually brings up a point Harold, I think, brought out earlier, which is a really interesting question here in a way, which is when you go back to the Stevens report and you look at the reasoning that was employed there, are we talking now about, applying the definitions using the same kind of reasoning that the Commission used in the Stevens report and just applying them to a different set of facts? Or are we talking about applying those definitions in a different way? And I've heard Harold at various times today sort of argue for both of those. In some cases that it's the facts are different, in some cases that it's we should change the way we apply the definitions. I think those are two really different changes. I think on the one hand, saying the facts are different, let's apply, let's look at the facts. Okay, that's something you could, that's one way to get a different result from what the Commission in 1998 decided about Internet access services. I think suggesting that we're going to change the way the definitions are applied now compared to the way we applied them then, I think that is really a very big change in the in the way the Commission is applying the statutory framework. And I think that was a big component of sort of, the letter from Seth Waxman that people were talking about earlier.
In my defense, I will only say that no, I'm saying that the commission ought to take a look at, use the statutory factors, and evaluate the marketplace of 2010 as with compared to both how its predictive judgment turned out, which it's required to do from time to time, and with regard to what actually takes place in the marketplace today, and as the Supreme Court said with regard to the Commission's ability to change its mind, look and determine what it believes is the better policy.
I think just to underscore that, by the way, when the Commission actually defended the cable modem order in court, if you go back and look at the transcript, one of the judges actually asked FCC counsel, what if your predictive judgment about how these services evolve is wrong? What would you do? And FCC counsel replied, I think we need to go back and look at these and see how they evolve and react accordingly. So even back then when the FCC cable modem order was being appealed, I think there was a recognition by the FCC and the court that these are evolving services, that you need to look at the facts and you need to re-examine the conclusions that the Commission's made at a future point in time. And I would submit that this time has arrived.
Barbara, final comment on this?
I just wanted to clarify one thing that Harold raised regarding CALEA, the Communications Assistance to Law Enforcement Act. CALEA has its own set of definitions. The FCC wasn't applying the Communications Act definitions. It was attempting to resolve a difference in the way the two statutes treated these services. Personally, I was not a fan of the CALEA decision. It was an expedient way of resolving a problem that the law enforcement community said was pressing. But I don't think it bears on the question before us that's being debated about taking this telecommunications component out of the integrated service and declaring it to be a common carrier offering so that it can be regulated.
Okay, so do we have questions? Oh, and please identify yourself when you ask. Yes.
Hi, Ryan Wallach with Wolfie Farr. I was just curious, if you reclassify as Title II, and 201 and 202 both modify rates and discrimination with unjust and unreasonable, are you going to get the protections that are afforded under the currently proposed rule? And if not, how do we address that?
Anybody?
We've argued that you do. I would note that the rules themselves are in flux. And the FCC proposed the actual FCC proposed set of rules in Appendix A of the pending NPRM are, as we observed at the time, and as I will say now, really pretty useless because they're self-referential. The FCC, in its solicitation of comment, asks about, the critical questions. Should we have tiered access of some variety? Should we allow certain types of discrimination? What kind of filtering should we permit? With regard to unlawful content. Our feeling is that, and we've said this in our comments, that anything you want to do on a theory of reasonable network management, no discrimination in unreasonable network management versus reasonable rates and practices, that pretty much you can get whatever set of protections under either standard, but you have a cleaner and better debate under the 201, 202 standard because you're not forced trying to deal with things that are actually economic or policy based as if they were technical network management. The fact is we had the reasonableness language in 201 and 202 was a congressional recognition that something is going to come up that nobody foresees, and you have to be able to have some kind of reality-based ability to adjust to that. There's always the problem that you deal with agency capture, you deal with the flip of this, which I know people in the public interest community who don't like the 201, 202 standard are worried about, agency capture, how you would interpret pre-existing 201, 202 decisions, depending on which ones you think are relevant. But, Carter phone was decided under 201, 202. That ended up working out just fine. I think we could do network neutrality under 201, 202 as well.
What about tariff-paying prioritization?
Well, again, there's nothing in 201, 202 that says you can do that or not do that. The question you ask is, for the nature of the service that is being offered, what would the commission regard as either reasonable or unreasonable? You can point to past precedent in certain areas where you would say, yeah, we allowed certain kinds of tariffs that treated people differently based on objective characteristics. The flip side of that is I can also point to precedent where the FCC said this would never be okay because it's just inherently not reasonable for some kind of particular action that was found to be unreasonable under 201 or 202. So with regard to tariff-based discrimination, that open and available to everybody on an equal basis, kind of perhaps modeled on the Section 315 advertising for political candidates idea. You could find power to do it under 201. You could find reason not to do it under 201. You can find reason to do it under the no discrimination reasonable network management. You can find reason not to do it under reasonable network management.
It's I think Harold's presentation is very fair-minded, but my reading of the precedent here is that part of what the FCC set out to do in the NPRM, it didn't just, its proposed rules aren't just muddled because they're self-referential. They're also muddled because in some important ways they don't say what they mean. So we have this situation where there's this reference to enhanced or prioritized services, that's what's not allowed by the non-discrimination rule. But the FCC doesn't tell you what any of those enhanced or prioritized services might be, so it's hard to know. But basically it seems to be saying that there's some blanket line of business restriction on offering a certain kind of service. Those are very rare in the common carrier world, that kind of blanket line of business restriction. I can tell you that all of the legacy packet services, whether we're talking about ATM or frame relay or any of these services, when they were tariffed at the FCC, they all had quality of service as one of the tariffed offerings that you could buy with those services. So the idea that you could go under 201 and then have such a blanket line of business restriction on the offering of this undefined thing called enhanced or prioritized services, I do not find it at all credible.
I guess from our perspective, the answer is yes, that by under 201, 202, you could, the Commission could establish the types of non-discrimination rules that we've been advocating, or this light touch regulation, that we don't think that those provisions necessarily that compel the Commission to do one thing or another, that the Commission under Chevron Step 2 will have discretion to decide what actually to adopt. And just to be clear, our position is not this ultra-regulatory, 251C unbundling requirements, tariffing requirements. What we're looking for really is a light regulatory touch, a backstop, something where the Commission says if there is some sort of discrimination out there that is unreasonable, we have, again, a forum to go to actually have that dispute resolved. And that's critical, we think, to the evolution of these services and certainly to spur innovation at the edge and in the new video marketplace.
I just don't think of Title II as a light touch regulatory framework. Most of the consequences attach by definition. You would need years of FCC proceedings to work out what didn't attach, what they didn't need to do. And for the reasons I've suggested at the outset, I think forbearance authority is pretty much precluded if your justification for going this route is insufficient competition in the last mile to protect consumers and competition. Just hearing about tariffing brings back the old days. I started in what was then called the tariff division. This is not a place that works essentially in a quick manner, although there are statutory obligations for tariff investigations to be concluded in a timely manner. But you are talking about a step back 10 years in regulatory history to a time when the regulatory wheels ground very slowly for the regulated entities. And I think before taking such a huge step backward, we should evaluate, were the predictive judgments really that far off? It was a bit of a gamble for the FCC to decide to rely as heavily as it did on the development of competition in this marketplace. But it's only been between 5 and 8 years now that these actions were taken. Maybe this is something that's going to take a little longer to work out. And to say from today's perspective, oh, huge failure, I think is premature and unwarranted.
I would just add one point to Linda's. I mean, I hear you say light regulatory touch, but in your reply comments, you basically call for two kinds of non-discrimination, one of which you describe as structural. Ultimately, the other one's about pricing. I mean, your reply comments in the net neutrality, in the open internet proceeding, basically say, Commission, to the extent providers implement usage tiers of pricing, you're going to have to review those usage tiers and the way they're applied to make sure that they're not discriminatory. I think that I do not view that as a light touch approach to regulation.
I think our only point was not that you review the tiers or the rates necessarily, but if a competitor were, such as Comcast or one of the other MVPDs, were to exclude from their tiers 100% of their video traffic, so that if you purchased, for example, a Comcast service and you had some sort of tiers imposed on you as a user, but any of your Comcast video was not included in any of those tiers, but if you subscribe to Dish or DirecTV or some other competitor, any video usage does apply. To us, that is a form of discrimination. It's just sort of a backdoor. So we're not advocating rate regulation or anything like that, but to the extent that there is some sort of discrimination that clearly ends up discriminating against a competitor and a competitor's use of that service, then that is a consumer issue, and we are concerned about it.
And we're wandering a little far afield, and I just need to say, in the Wireline 2005 framework, the Commission found, without needing to go through a forbearance proceeding, that those guys who wanted to still offer this under Title II could do it on a, quote, competitive detariffed basis. I'll also point out that we're having quite a fight in the special access, where in special access phase 2 deregulation, do you guys file tariffs in those markets where you have phase 2? Right.
I don't do special access.
So, the fact is that Title II turns out to be a pretty flexible instrument. There's a lot of precedent within the FCC's history for how they interpret these statutes. I think particularly with regard to if the FCC were to actually move tomorrow to a Title II regime, they could easily say, under their existing authority to establish interim rules, for now we're just going to do 201, 202, and 208. Anybody who thinks they're being treated unfairly, bring a 208 complaint, and we'll work the rest of this out in our various pending proceedings and as we move forward.
So we should wrap up in just a few minutes, but there's been a hand, right here. And actually, why don't you, give your question, and then the only other one back there, Austin, immediately give theirs, and then we'll just go right down the row and give each person a chance to make final remarks addressing whichever of you is more relevant to them.
Whole different direction. I'm Bruce Hahn with the American Homeowners Grassroots Alliance. We're a consumer advocacy group. Mm-hmm. There has been tremendous amount of discussion about what the FCC can or cannot do as a result of the BitTorrent decision. Like your opinions on what do you think the potential is for consumers to fill any void that might exist in the FCC regulatory authority, either directly or indirectly. And what I mean by that, for example, if you take a pessimistic view and say, okay, FCC doesn't have a lot of authority, some company goes out and decides to block very popular applications or very popular websites. What do you think consumers would do? And their competitors, would they migrate to competitors? would their competitors stand by, or would their competitors encourage that? And the kind of ad wars we've seen between Comcast and Verizon and AT&T and Verizon. And what about the secondary effect? Linda made the point that I think Hill aides said they don't see anything happening on the Hill in 5 years. Very big issue to us is the financial services regulation as a result of the subprime mortgage meltdown. If you would have asked 4 years ago, were they going to regulate the financial services sector, you would have gotten the same reaction. We're working on the law that's going to pass, and the financial services sector lobbyist is one of the most effective, if not the most effective, in this city. Wouldn't the ISPs take that into account? Wouldn't they look at that as shooting themselves, or would they, as shooting themselves in the foot if they stood by or decided to do the same thing of any one of their competitors that violated?
Okay. So what can consumers do? And was there a burning other question or no to throw in with this, and then we'll give everyone one quick crack.
Quick question. My name's Kerry Hinton. I'm with the D.C. Public Service Commission. A point that Harold raised in his opening comments I don't think was addressed by the panel, and I'd be interested in your response. And that point was regarding, and maybe I can phrase it a little bit differently, is it reasonable to expect that the customers of telecommunications service providers that are making contributions to the Universal Service Fund for high-cost fund, and now as proposed in the NOI NPRM that was released recently, a Connect America fund, which of course was an outgrowth of the National Broadband Plan, is it reasonable for those customers that are making contributions into those funds to pay money that then can be drawn upon by companies that desire to be under Title I regulation, not under Title II regulation?
Yes, I think the FCC, to the extent it establishes a universal service program, is free to set whatever requirements it wants for the recipients of that program. And if the FCC were to decide that the recipients of this program have to offer the underlying transmission the way the rural phone companies do today, that would be the FCC's decision. I think they would weigh that against the impact that would have on participation in the program, and they would have to decide which best promoted the public interest. But that's plainly a requirement which they would be free to impose. I think the other question regarding the consumer impact, look, there's a reason why, Comcast wasn't, upfront about what it was doing with respect to BitTorrent, because it didn't want its customers to know. I assume that was in its self-interest, and that their expectation was that if they came out and told their customers what they were doing, it would have had some impact on them. So yes, I won't speculate as to the size of, the likely impact, but I think there is an impact. I think in an industry like this, where there are significant returns to scale, any loss of customers at the margin has a significant impact on the average cost overall, and I won't bore you with the way the cost curves work, but it is significant.
I just have one comment to the gentleman's first question. Part of the problem here is if there is no authority, a very large portion of this proceeding is about transparency. And one of the problems that was alluded to in BitTorrent is that consumers realized that somehow something was wrong, but they didn't know what it was because it was sort of random and it happened with certain programs and not others. They didn't know, was it their computer, was it their service? And so if you don't have the transparency piece here, which obviously you can't mandate if you don't have jurisdiction, then you have a problem that consumers don't necessarily know that there is a problem, and so they can't use the market to go to some other provider if they don't understand that it's a problem because of their service provider. So again, transparency is critical. It's part of this equation. And I think with respect to the USF comment, I think, yes, putting the restrictions on the recipients of USF from our perspective is not terribly helpful. First of all, Verizon, who has Fios, and AT&T, who has UVerse, are not typically the recipients of USF, and I think the point that the gentleman in the rear was making is that their customers are the ones that are having to pay into the fund, and yet they could be discriminated against and actually have services where they have no recourse. And so actually pinning the obligation on the recipients of the funding doesn't get to the critical piece of this, which is the consumers paying into the fund are not necessarily getting the services that they would like and desire.
Barbara?
I agree completely with Linda that transparency is a key to consumer protection. I also believe that the Federal Trade Commission is probably fully empowered to look into this area and develop best practices or rules under its authority. As to the aggrieved consumer, I'd suggest that they could do what has been done for the past few years. Pick up the phone, call a reporter, get on the internet, and I'm sure their email is not blocked, and send an email, post something on their Facebook page, use Twitter, call the Net Neutrality Squad, call the State Attorney General, call the Federal Trade Commission, or the Better Business Bureau. These people are selling services. If you come to believe you are not getting the service you're paying for, there are many avenues in this country for redress. Not every problem requires a sector-specific regulator to solve it.
A couple of points. One is sometimes consumer vote works. Targeted advertising was a good example. Where, boy, did that industry crater in 5 minutes after people found out about it. On the other hand, the BitTorrent stuff did not end until the FCC told Comcast to end it. We know this because that's what Comcast told us. The Comcast case to me is very instructive in a lot of ways because people did all this stuff of shout to get it out, try to move it. Didn't happen until it happened to be that there was a guy named Rob Topolsky who also managed to get the AP interested. And even then, nothing happened until it looked like the FCC was going to take action. I do, however, have one suggestion. One of the things that's clearly eliminated as a result of the Comcast decision is preemption authority. The FCC has no statutory ability to preempt the information services. I would highly recommend that PSCs, local PSCs, the laboratories of democracy, the other states who are now empowered to handle all of this, should consider how to protect their citizens and how to protect their consumers from complaints. I am sure that rather than have terribly burdensome Title II regulations, providers like AT&T will welcome the opportunity to serve under 50 different complaint regimes. I mean, God knows they love it right now with state PSCs, so I'm sure that, in the new, exciting, unregulated world of information services that they have wished upon us, that they will not object to the laboratories of democracy working their magic.
Well, Harold, that sounds like a great idea for another event we can have with some of the activist state regulators talking about how they're going to do their own net neutrality regimes in the future, and they can compete with one another. So with that, let me thank the audience for hanging in on what turned out to be an incredibly substantive, wide-ranging discussion, and for the same reason, thanks to the panel for providing it for us.